This is a devastating tragedy that has befallen the Reiner family. We all recognize that. Our hearts go out to the entire Reiner family. There are very, very complex and serious issues that are associated with this case.
And it was that statement from Nick Reiner's attorney, Alan Jackson, that could be a preview of potentially several different kinds of legal defenses that could be mounted in this case of the man accused of brutally murdering his parents, Rob and Michele. From mental health to the sufficiency of the evidence to mitigation to potentially self-defense, we want to examine what theoretical defenses could come into play as we explore this rapidly developing story. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now, here's the truth. I don't know if we'd be able to put these episodes together if it wasn't for the incredible support that we get from our sponsors, and that includes Morgan & Morgan. This is America's largest personal injury law firm. This is a firm with over 1,000 attorneys who have recovered $25 billion for more than 500,000 clients. Think about that. In the past few months, a client in Florida received $12 million when insurance offered just $350,000. Out in Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. And Morgan & Morgan, they make it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/LC sidebar. You can click the link below, or you can scan the QR code on screen. Now, as we know, 32-year-old Nick Reiner has been formally charged with 2 counts of first-degree murder in connection with the apparent stabbing deaths of his parents, renowned director Rob Reiner and photographer and producer Michele Reiner, who were found dead in their Los Angeles home back on December 14th. What we haven't discussed yet are the potential defenses to be on the lookout here. Because as we go through this evidence, you do have to wonder, is this a slam dunk case for the prosecution or not? That is what we want to go through. And to understand potential defenses, we have to go through what we know right now. Like, for example, it has been reported that the death certificates for this couple indicate that they died just within minutes of sustaining, quote, multiple sharp force injuries inflicted with a knife by another. That Rob was apparently found at 3:45 p.m., Michele about a minute later. By the way, it was reported that the couple's daughter, Romy, was the one who found her father dead after the couple weren't responding to a scheduled massage therapist appointment. Now, Nick was arrested hours later in the Exposition Park area near USC. The Santa Monica hotel room where Nick apparently checked into at around 4 a.m. Sunday the 14th, apparently using his own credit card, which is, by the way, potentially quite incriminating because he reportedly had been living in the back house of the Reiner's property. So why check into this place at all times? Well, it's been reported there was blood in the shower and the mattress of that room. He's currently being held at the Twin Towers Correctional Facility. And this comes as there is footage that has surfaced that's been released of apparently Nick allegedly walking alone at a gas station close to the Reiner family home a little after midnight on that Sunday. There's also apparently footage of him allegedly in a convenience store right before his arrest as well. By the way, I will tell you, I think his apparent demeanor in that footage, assuming it's him, could be critical in a potential defense, which I'll talk about more in a minute. And this all comes as it was also reported Nick had attended a party at Conan O'Brien's house the night before the killings, in which he allegedly went around asking strange questions to guests, got into this apparent weird interaction with actor Bill Hader, then had some sort of loud argument, potentially with his father at the party. His parents left shortly after. A source told People, quote, Nick was freaking everyone out, acting crazy, kept asking people if they were famous. I will say family friends have reportedly said the fight was overblown. But we also know, and we did a previous episode of Sidebar, a full in-depth breakdown of the backstory of Nick Reiner, that this is a man with a serious history of substance abuse issues, that he's been open about that, talked about his struggles since he was 15 with heroin, that he was homeless, that he was in and out of rehab, that he and his father collaborated on a film known as Being Charlie, which was released in 2016, that's about a young man addicted to drugs and his difficult, combative relationship with his former actor father, who's cold and distant as he tries to recover. Rob, by the way, directed the film. So with all of that in mind, as Nick Reiner faces these murder charges with special circumstances, namely multiple murders, there's also a special allegation that he personally used a dangerous and deadly weapon, a knife. We're talking now the death penalty on the table if convicted, or at least life in prison without parole. Death penalty questionable, by the way, because there's been a moratorium on executions, but serious consequences nonetheless. And he's already made his first court appearance and currently hasn't entered a plea. His arraignment is set for January 7th. The question again is, what could be his potential defenses here? Because it seems like alternative suspects may be tricky, still in the early stages, but what may theoretically, what may possibly be something that Alan Jackson explores here? That's what I want to talk about. Okay, so let me bring on former federal prosecutor Neama Rahmani to talk more about this. Neama, thank you so much for taking the time. All right, I got to start with the big one here. A lot of people have been talking about this, insanity. Now, I mean, one of the prime reasons that I think this is coming up, in my opinion, is because of what Nick Reiner's defense attorney, Alan Jackson, told to reporters after a court hearing. Take a listen.
There are very, very complex and serious issues that are associated with this case. These need to be thoroughly, but very carefully dealt with and examined and looked at and analyzed.
So to me, making a statement like that, right, complex, serious issues, before a defense attorney has the opportunity to see all the evidence or know if there was like a constitutional rights violation, it seems to me he's talking about mental illness, mental health. Could be wrong. Neama, before we get into the specifics of how insanity and how mental health could play specifically into this case, just to put that to the side, just so everybody knows, procedurally, how does an insanity defense work out in LA?
Jesse, thanks for having me. And Alan Jackson, of course, is one of the best, not just in the courtroom, but outside the courtroom. So there's certainly a PR battle being waged here. But here in California, when you're talking about legal insanity, the trials are bifurcated. So first, there's a guilt phase that we typically see. Did the defendant do it or not? Is he guilty or not guilty? If the defendant is guilty, then we move to a second phase where the burden shifts to the defense, and it's based on a preponderance of the evidence. And here in California, we follow the Manhattan test, which says that because of a mental disease or defect, the defendant didn't understand the nature and consequences of his actions. Basically, he didn't know right from wrong. But the reason procedurally the bifurcation is important is it's very difficult for defendants and defense attorneys to really pivot. Sometimes you'll see them try to argue self-defense or it wasn't me. And then when the jurors return a guilty verdict, they say, no, it was me, but the defendant was legally insane.
Yeah.
So it's hard,
Can I ask you about that?
Yes.
I mean, typically, how does it work? Do they go and say, hey, listen, he wasn't the one who did this? Or do they question the state's evidence, right? They question whether or not the state has proved beyond a reasonable doubt all the elements and then say, okay, we respect your decision. But after all that, I know we were casting doubt on him doing this. We're really going the insanity route. Or do they just say, hey, listen, we're not going to fight. We're not going to fight the trial phase. Do they plead? They can't just plead guilty and then go into the insanity defense. Am I wrong? I mean, I don't know how it works.
They can. And I think the better practice is to accept responsibility and move straight to the insanity defense. We've seen this sometimes with defendants who are facing the death penalty. Nicholas Cruz, for instance, right? We covered it here on Law&Crime, worst school shooting in American history. He pleaded guilty to 17 counts of murder and 17 counts of attempted murder. They went straight to the death penalty phase, and they were able to maintain some credibility, and they ended up saving his life. But when you defend it on both grounds, it ends up being tougher. I do think you lose credibility with the jury. Right. Now, there are some other ways that mental health may come into this. I can't see Alan Jackson walking into court and pleading Nick Reiner guilty and moving straight to insanity, because insanity, again, is very tough. It only works really a very small percentage of the time, at least here in California.
Let's talk about that. So you're right. If you look at the law, it says because of that mental disease or defect, this person was incapable of knowing or understanding the nature and quality of their actions, or was incapable of knowing or understanding that that act was morally or legally wrong. Now, again, before we get into the specifics of Nick Reiner, generally speaking, how does a defense prove that? I mean, who do they call? How do they prove it? At the time, these killings happen, right? How do you prove it at that time? And what evidence is introduced? And what does the prosecution do to rebut it?
So obviously you rely on mental health experts. It seems like Nick Reiner was under the care of a psychiatrist. He's obviously been in and out of rehab, at least what's been reported. From the prosecution's perspective, obviously they call their own witnesses, but you just look at the facts of the case. Jesse, if you're capable enough to have an argument with your parents and even know it's your parents at Conan O'Brien's Christmas party the night before, and you're capable enough to go to a hotel in Santa Monica and wash off all the blood and close the curtains and go to a gas station and get a drink, that doesn't strike me as legal insanity. It's really a high burden. We talk about this person's crazy or insane. We throw that out a lot, but to really not know the nature and really consequences of your actions, not knowing right from wrong. You really have to think like you're killing a demon or an alien or God or the dog is telling you to do something, but you don't really know that's wrong. It's very difficult to prove.
It's very difficult to prove, but let's apply it to this case. So there are reports from outlets like the Los Angeles Times and KNBC that Nick Reiner was receiving medical treatment for schizophrenia at the time of the deaths of his parents, okay? First of all, if that's introduced, is schizophrenia the type of mental disease or defect that could be necessary for insanity? Let's start there.
It could be. It's certainly one of the ones that is most commonly argued in these types of cases. So that's certainly, I'd say, a first good step for Nick Reiner. But it's not enough. It's necessary, but it's not sufficient. Going back to the old LSAT days. So just being schizophrenic does not make you legally insane if you know right from wrong.
But here's the thing, Neama. Okay, if you look at that footage, right, the demeanor of him, or allegedly him, in that footage, walking by the gas station, in the convenience store, to me, it's eerily calm. If this is, we don't know the exact time of death, but if this is somebody who just massacred their parents, you want to talk about a fact pattern. Isn't a fact pattern somebody commits a brutal murder and then just sits there and waits and acts like nothing's happening? Now, I don't know what he was thinking at that point. It's hard to just judge from the footage. But when I looked at that, I said that could be something that Alan Jackson may be working with if you're talking about an insanity defense. Am I totally wrong here?
No, you will try to use it, but being a stone cold killer doesn't make you legally insane. We have seen these types of murderers with that type of affect. Brian Koberger, right? I mean, he's shown little to no emotion at any time during the many years that he's been in court, and now he's going to serve the rest of his life in Idaho State Prison. So it does fit the profile of a killer. Again, if you know what you're doing, again, you're able to walk to a gas station, you're able to pay for a drink. That is not someone who's legally insane, in my opinion.
What about getting a hotel room? I think that you're probably right. That see, I mean, he was apparently living with the parents, so getting a hotel room out of all times, what do you think?
Yeah, getting a hotel room at 4 a.m. in Santa Monica where you wash off the blood in the bathroom and it gets all over the sheets you clean up. Again, someone who's legally insane isn't capable and coherent enough to clean the blood off them. I get it. You know, there has to be some sort of defense, and I know Jackson will come up with something, but the actions before and after, to me, are not consistent with someone who's legally insane.
There are two parts to this as well. So I'm going to get to the other idea, how mental health may downgrade the charge, in a second. We'll get to that. Just focusing on insanity, though, the reports of how he was acting at that party, Conan O'Brien's party, the night before, and nothing's been officially confirmed by law enforcement. But if he gets into an argument, is asking weird questions of guests, is that help the insanity defense or not? You seem to suggest if he's capable of getting into a coherent argument, that would suggest he's not insane, right?
I would, because look, you're asking someone what their first name is, what their last name is. Are you famous, right? You argue with your parents. You have to leave. And again, we're going to have a lot of famous celebrities here in LA who are going to testify at this trial. I do believe it's going to go to trial, whether it's Bill Hader, whether it's Conan O'Brien, other folks. They're going to say, listen, here's someone who's acting erratically, but someone who, again, if you know it's your parents, and you know that this is a famous person, that just doesn't strike me as someone insane. Maybe this is a former prosecutor in me, and I'm being skeptical, and I just know how rarely this works. I don't think it will. Now, maybe they go in a very different direction, and they don't argue insanity, and they say that he was drugged. You have an involuntary intoxication defense. I think that's something that is more likely to work than legal insanity, in my opinion.
Just to be clear, any kind of insanity defense or a mental health defense would be negated if he was voluntarily on drugs. So whatever effect the drugs had on him, he couldn't then argue he was acting insane, right? It doesn't work.
Of course. Yeah, we know voluntary intoxication is not a legal defense. Involuntary, maybe. And again, we know based on Karen Reed that the defense may present a very different alternate theory of the case. And one of them may be, listen, here's someone who's been sober for a while, right? Reportedly has been off drugs since September. He goes to a party, someone spikes his drink, and there you go. Things spiral. Now that would be creative, but it would actually be a legal defense.
And just to be clear, before we move on to more mental health ideas, if he took something and the effects of it were completely different than what was anticipated, if there was laced with something, because I've seen cases like this before. Somebody might smoke marijuana, it's laced with something, it has an effect they weren't anticipating, and they commit a crime. Can that downgrade a charge? And we'll get into that a little bit more, but can it?
No, generally speaking, if you voluntarily take drugs, you're responsible. So if it's laced with like PCP, for instance, that'd probably be the most likely psychedelic that could cause someone to do something like this. You're responsible. But if you're taking a legal drink, an alcoholic drink, and something like that were to happen, then you would have a defense.
Got it. Okay, before we go through past insanity, I just have to ask you this. The reason this is a defense that people are talking about is because if someone is declared insane, right, not guilty by reason of insanity, what happens to them? They go to a psychiatric facility, not prison, and for how long?
They're committed for the term of the sentence until a determination is made that they are now returned to sanity, in which case they can be released to the general population.
Okay, so this is why it's a big deal. Now, putting insanity away, I think there is a second related defense that's come up. That if you talk about mental illness, that he won't be found not guilty of first-degree murder due to insanity, but he could be found not guilty of first-degree murder, but rather a lesser charge because of his state of mind, because of his mental health. Can you explain that?
Yes, so first-degree murder, of course, requires premeditation, the intent to kill. Now, voluntary drug use and mental health can negate the specific intent for a crime. So it can reduce first-degree murder, the premeditation, down to second degree. Why is that a big deal? Now, District Attorney Nathan Hochman has talked about the death penalty. That's not realistic. We haven't had an execution here in almost 20 years. But first-degree murder with special circumstances does carry a mandatory life without the possibility of parole sentence. Second-degree murder without special circumstances would potentially be as low as 15 to life on each count, which would give him the chance of parole at some point in his career. Now, some more conservative attorneys may go that approach and say, listen, he did it, but talk about the drug use, talk about the mental health. He lacked the specific intent for premeditation, right? He just walked into the bedroom, something happened, right?
So can you explain that? So put aside any kind of drug use for a second, because we don't know 100% if he was on any substances at the time. If he was, just for argument's sake, if he was schizophrenic and he was having an episode, so it doesn't mean that he's insane at the time. What's the argument? What's the fact pattern laid out by defense that would say he's not guilty? He didn't have the intent to kill, but yet killed his parents and was schizophrenic. Like, how would that, again, explain that to us a little bit.
Yeah, so, I mean, obviously the prosecution is going to argue that this was premeditated. This was all related to that argument at Conan O'Brien's house, right? They're there, they fight, they come back to the home. Reiner comes back with a weapon, goes into the master bedroom and kills his mom and dad, right? The defense will say, no, that episode passed. He went into the bedroom. It was a different, unrelated argument. It was not premeditated. He did not come with a knife. The problem is when you get in an argument and you come back with a weapon under California law, that's first-degree murder. That's premeditation. That's what happened in the Nipsey Hussle case, right, where they argued manslaughter in second degree. But you come back with a weapon after any period of time, that is enough for premeditation. So the defense will try to separate that argument, separate that episode from the night before, and say, hey, something else happened. It was really spur of the moment. Not enough for manslaughter, but certainly enough for second-degree murder.
Right.
That will give the defense and the defendant, Nick Reiner, a chance of parole at some point in his life.
Okay, so this now goes into another defense that I'm curious will be explored, and I don't know if there is anything to substantiate this in any way. I haven't seen anything that would. I'm talking self-defense. Now, I would imagine a self-defense argument would be a complete not guilty or maybe a conviction for manslaughter, right? Heat of passion. Is there an argument that he was defending himself from an imminent threat from his parents, acted in the heat of passion in the moment. You know, there was, for voluntary manslaughter, there was terror, there was anger. I'm assuming after this reported, let's say, altercation at the party, if that's true, anything there?
It's gonna be tough. You know, you got Rob Reiner, who's 78, right? Michele Reiner, 70. You know, you got Nick, who I believe is 32 at the time. That's a big age difference, right? For you to credibly argue self-defense. Now, when it comes to self-defense, there's two types here in California. There's perfect self-defense. If you reasonably believe you're at imminent risk of death or serious bodily injury, you can use deadly force, similar to the rule in many states. We also have imperfect self-defense, which says that if you genuinely but unreasonably believe you're at imminent risk of death or serious bodily injury, and you use deadly force, that reduces murder to manslaughter. Obviously, a big deal if they are able to prove that. So that's one of those ways that maybe the mental health can come in. It's going to be tough, though, to argue self-defense against your parents, especially if they don't have any type of weapon.
And I would also imagine what would complicate that argument is they were apparently found in their bedroom late at night, multiple wounds, a knife. Those are all complicating factors for the defense, right?
Oh, no question, you know, and there's different reports. We know that at least from medical reports, we have multiple stab wounds. There were some reports unconfirmed that their throats were slashed. Obviously, that would be bad for self-defense if that were true. Being in a master bedroom, again, makes it less likely that you're going to be defending yourself against someone in their master bedroom. It does seem to be at least circumstantial evidence of premeditation that you went in to attack them.
And he would have to testify about that, Nick Reiner, I'd imagine?
Usually... Yeah, Jesse, the conventional wisdom is in a self-defense case, the defendant has to take the stand. So obviously that would subject him to a grueling and rigorous cross-examination.
I want to backtrack on one thing before I go to another defense. This is also sort of a defense. Could a history of mental disease or a history of addiction, can that be used as mitigation for sentencing to lessen the sentence in some way?
It absolutely can. You know, the issue is obviously if you get hit with that first degree special circumstances, the judge has no discretion to go anything less than life without the possibility of parole. But absolutely, all that evidence can come in to sentencing if there's an indeterminate sentence and a judge can sentence within a range. That comes in all the time in any type of criminal case.
And of course, maybe a way to get the death penalty off the table, maybe even in front of a jury if they hear that. And this is another defense that I wanted to get into, where the defense legitimately attacks the aspects of the prosecution's evidence. You know, we're seeing this in the Mangione case, where I think the evidence is, you know, quite strong that he committed the crime, but can they get evidence thrown out on the basis of a tainted investigation, that a defendant's rights were violated in some way? You know, one of the key ways defense attorneys can dismantle a prosecution's case is to get the evidence tossed out. And when thinking about that, when thinking about the evidence, before we go into it, I just want to go back to what Los Angeles District Attorney Nathan Hochman said at an earlier presser.
At the appropriate time, the actual evidence involved in this case will be presented in a court of law. So I ask for your patience until that is done. But again, please do not rely on rank speculation, rumor, or hearsay to believe that you understand anything about what went on in this case.
So Neama, again, they haven't revealed what the evidence is, the forensics, the digital evidence. We get samplings of it, but talk to me about the ways that Alan Jackson and Nick Reiner's defense team, what they could do here. And again, it's difficult because authorities haven't revealed a lot of the evidence yet, but what are ways they could get evidence tossed out or question the evidence?
We've seen in Mangione in many cases where the defense will file suppression motions, say that evidence was unlawfully seized, often in violation of the Fourth and Fifth Amendments of the Constitution, really to go on the offense. Now, we saw in, again, the Karen Reed case where they really put Massachusetts law enforcement on trial. They really destroyed the lead detective, Michael Proctor, in that case. So good defense lawyers, what they do is they point to sloppy investigation, rush to judgment. These are themes in many defense cases. They try to get evidence suppressed. They'll say that evidence was planted. Again, I don't know how careful Nick Reiner was. I imagine that a house in Brentwood has surveillance video, and he didn't seem to be particularly careful in terms of his cell phone and where he went after the murder. But it's certainly possible that they can get some evidence tossed and suppressed and put LAPD on trial. They certainly don't have the best track record, and I say it respectfully as someone who lives and works in Los Angeles. They have botched some big cases. So given Alan Jackson's sort of track record of going after law enforcement and LAPDs, it's possible, but again, I think it's very unlikely. This strikes me as a very strong case and one that's going to be difficult for Jackson and the defense.
Because they seem very confident that he did this for whatever reason. I don't know if it was the hotel room that was allegedly stained with blood, the surveillance footage. They haven't indicated, at least as far as I know, where the murder weapon is or the circumstances of that. But you would say that they feel fairly confident in the evidence they have against them at this point and the sufficiency of the evidence and the way it was collected.
I do. In these murder cases, you typically see three defenses, right? It wasn't me. I mean, it seems like the evidence is going to be strong again. Usually in a multiple murder stabbed crime scene, there's going to be a lot of blood and other DNA evidence. I expect to see that in this case. The other is self-defense. We talked about it. The third is, I didn't mean to do it, right? It was an accident. It was manslaughter. It was something less. So I think they're probably going to have to go in that third direction, try to attack the intent somehow. Say it wasn't him and it was someone else that did this, I think it's going to be a tough legal and factual hill to climb. But we'll see. Maybe they'll pull a rabbit out of their hat.
Yeah, I haven't seen anything indicating alternative suspects, but we're still early in this case. And if that should develop, maybe we'll do another sidebar on that one as well. Neama, thank you so much for taking the time and breaking it down with us. Really, really appreciate it. And healthy, happy New Year if I don't see you beforehand.
Thanks, Jesse. Happy New Year to you too. I'm sure we're going to be talking about this one for quite some time.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.